Hello, everyone. This is Tom Fox, and I'd like to welcome you to the 100th episode of This Week in FCPA. This week, we have a special guest announcers.
Hi, I'm Millie.
And I'm Michaela.
A little bird told us that it's your 100th episode
of This Week in FCPA. Hey, Millie, what does FCPA stand for anyway?
It stands for Fake Cat Pac-Man Actors.
Are you sure about that?
No, not really. Do you know what it stands for?
No clue. That's why I was asking you. Anyway, Tom and Dad,
we both want to congratulate you on your 100th episode of This Week in Fake Cat Pac-Man Actors.
Millie!
Thank you, Millie and Michaela. And now a word about our sponsor, Affiliated Monitors. Founded in 2004, Affiliated Monitors provides professional and independent integrity monitoring and ethics and compliance assessments nationally and internationally and across all industries. With its knowledge of effective ethics and compliance programs and cultures, Affiliated Monitors is respected for its work as the corporate monitor on matters ranging from multinational corporations to small to mid-sized companies and even individuals. Having served in over 700 monitorships, no one has more experience as an independent monitor than the team at Affiliated Monitors. For more information on how an independent monitor can help improve your company's compliance and ethics programs, check out the Affiliated Monitors website, www.affiliatedmonitors.com. In today's episode, we take a look at a wide-ranging list of topics, including the Dun & Bradstreet FCPA enforcement action, which was recently concluded. We take a look at transparency around the selection of monitorships, the Yahoo data breach, the Facebook continued imbroglio, and a variety of other topics. I know you will enjoy this 100th episode anniversary edition. This Week in FCPA is a part of the Compliance Podcast Network. Hello, everyone. This is Tom Fox, back for the 100th episode of This Week in FCPA. Yes, boys and girls, ladies and gentlemen, madames and messieurs, senors and senoritas, Jay Rosen and I have hit that auspicious anniversary of 100 episodes of This Week in FCPA. So we are celebrating this week for the week ending April 27th, 2018, with the appropriate name, the 100th Anniversary Edition. So Jay, welcome.
Thanks, Tom. Let's jump right in. We're going to have a jam-packed 100th anniversary episode. Fair enough, Jay.
So starting off, we had a FCPA settlement this week that I think is very significant. Dun & Bradstreet settled their FCPA enforcement action with receiving a declination from the Department of Justice under the new FCPA corporate enforcement policy. They paid fine, penalty, and profit disgorgement to the Securities and Exchange Commission of $9 million. Like I said, this is the first FCPA case we have seen under the new corporate enforcement policy, and very interesting. I think it really portends a new era for compliance, emphasizing the importance of doing compliance during the pendency of any investigation. And I think we can only give a big kudos to Dun & Bradstreet for coming out of this very long journey at the end of the day with such a superior result.
I wholeheartedly agree, and we can always read the tea leaves in what the press release says from the DOJ, and it says through thorough investigation and full cooperation, including making current and former employees available for interviews and translating foreign language documents to English. So that kind of heartens me for my old life. And finally, D&B has enhanced its compliance program and its internal accounting system controls, and they fired 11 individuals involved with the China misconduct. So we got a little bit of everything here. We got the new enforcement policy, some individuals prosecuted under Yates. So this certainly does look like the way forward in the new year.
So I'd just like to end this segment, Jay, with the DOJ specifically stating, quote, "We have reached this conclusion despite the bribery committed by the company's subsidiaries in China." The effect of the new FCPA corporate enforcement policy could not be more clear from that statement with bribery in China, yet they received a declination. So once again, kudos to Dun & Bradstreet, and we're going to have to see. I think this is going to make compliance programs, compliance practitioners, compliance professionals, and chief compliance officers even more important going forward, Jay. So we've got, I thought, a really interesting article around transparency and monitorships over on the NYU Compliance and Enforcement blog. You want to tell us about it?
Yeah, so I think we've been following this matter for, it might be 18 or 24 months, but Dylan Tokar, who was a former employee, former reporter at Global Investigations Review, Just Anti-Corruption, had filed a Freedom of Information Act with the DOJ to reveal the names of monitor candidates that have been working on monitorships over the past several years. He had been denied at several steps, but finally the court is agreeing with Mr. Tokar and says that they're going to release the names of folks who were up for different monitorships. In Veronica's article, she cites three different instances, once in 2011, once in 2015, and now in 2016, where there was a situation where the courts wanted to step in and reveal certain information about DOJ monitorships. And at each step of the way, the court was reversed and saying that this information did not belong to the court. It was not court records, and it was the private information of the companies being monitored. Now, Veronica's position that she takes in her article is that she says, in the past, she may have argued whether a monitor's open report should be protected by confidentiality versus disclosed to the public depended at least on part of the goals of the monitorship. The notion, however, that the identities of monitorship candidates should be kept protected, at least in my mind, does not seem worth the fight. So it's been some interesting back and forth. Tom, what do you think about making those names public?
So it would certainly, I think, obviously lends itself and leads to greater transparency. I think it's given the perceived abuses around monitorships in the past, where we had monitor fees north of $50 million, and a DOJ response to that. I think we're moving towards having greater transparency, and I can only think it would help not only professionalize monitorships, but bring a level of comfort, perhaps, that everyone is being treated fairly and no one's being given either inside information or insider status.
Yeah, I would agree too that it's a good thing to bring additional transparency in. The next article we have is also from Global Investigation Reviews. And recently in New York City this past week, there was a Practicing Law Institute conference on anti-corruption development. And there was a panel that Charles Cain, the Securities and Exchange Commission's FCPA unit chief, was on, and they asked him about the new, or the relatively new, ISO 3701 anti-corruption, anti-bribery standard. And Charlie Cain said, I'm a little skeptical of the ISO 37001 certification. It does have a little bit of the flavor of a check-the-box exercise. And this is something that we've been ping-ponging back and forth for the past couple of years as the standard was being developed, and now that it was introduced. And this is gonna, I think, continue to be out there, although both Walmart and Microsoft have gotten this standard. I know, Tom, that you had a debate a while back ago with Christy Grant Hart about ISO, and have your views changed at all on the matter?
Not in the least.
Okay.
So I guess, Jay, the takeaway I would takeaway from this. I suppose that's a meta comment about meta comments. Nevertheless, when you have the regulators voicing concerns, it's certainly one thing for you and I to say the regulators are going to have concerns. But when you have the chief of the FCPA unit at the Securities and Exchange Commission raising real concerns, and one, it's a paper program. Two, it's going to require, it's really not something that's going to be on its face persuasive. It could be some piece of evidence the government would look at. But people need to understand that this ISO standard and an ISO certification does not protect you. You still have to actually do compliance. You have to operationalize your compliance program. And I was really gratified that a regulator would express at least that they have some concerns, because I think it drives home the point that ISO 3701 certification is not going to protect you either if you have it yourself or if you have it from a third party.
I'd like to button up with Charles Cain's final quote on this in the article. And it says, if you can't tell me why it works, then it probably doesn't work, and you aren't good at your job because you did not tailor it to your company or to your specific risk analysis. So I think that shuts the door nicely on it. Next up, tell us what's happening to our friends Yahoo up in the Bay Area.
Well, Jay, I would have to say they're our former friends because Yahoo doesn't exist anymore. So Yahoo agreed to a $35 million fine penalty to settle charges that it misled investors in failing to disclose one of the world's largest data breaches. This was, I can't remember, hundreds of millions of account users. I was a Yahoo account holder. So I was one of them. And Yahoo knew about this data breach for over 2 years before they disclosed it. And they would never have disclosed it but for the merger they engaged in, or that were bought by Verizon. And it came out in the pre-acquisition investigation. This was just complete irresponsibility by Yahoo. They knew about it back in 2014. They disclosed it in 2016. The penalty, I thought, was just way less than what the company deserved. Now, the penalty was not for not disclosing. It was for not disclosing in a way to mislead investors, because I think the SEC properly recognized that had Yahoo disclosed this, their stock would have taken a tanking. So this is the first real significant SEC action involving failure to disclose data. If this had happened 29 days from now, after GDPR goes live, the fines would have been exponentially higher just in Europe alone. So I think the SEC is finding its way on this issue, number one. Number two, they recognize that Yahoo no longer exists, and that hopefully Verizon will be a little more forthcoming in terms of communicating to its account holders when its data is breached. But it's still the first. So in $35 million, obviously is not something to laugh at.
So it would be fair to say after, where do we go all the way back? Home Depot and Target, that it is probably good operating policies and procedures that if you know of the fact that your company's internet and security has been breached and you've had a data breach, that it would probably make sense to be as forthcoming as you can and let the regulators know about it as soon as possible.
Well, it's certainly going to be a legal requirement now after GDPR goes live May 25.
Totally. Now we have another story that comes to us from GIR, Just Anti-Corruption, by Kelly Swanson, former FCPA Chief Pat Stokes hits back against the government use of broad tolling agreements. What's Pat talking about?
So, Jay, a tolling agreement is something that suspends a statute of limitations, and that's significant in the FCPA world because there's a 5-year statute of limitations, meaning you can only go back 5 years. So from today of April 27, 2018, that would be April 27, 2013. If it was April 26, 2013 or before, it would be barred by the statute of limitations. Typically, what a company is asked to do by the government is sign what's called a tolling agreement, saying the statute of limitations will not be brought into play during the pendency of that enforcement action. So if we use my date example again, everything from April 27th, 2013 forward up until the resolution of a case, if there was a tolling agreement, could be covered in the enforcement action if the tolling agreement was signed. What the Department of Justice, or at least Pat Stokes' concern is he thinks the DOJ is being too aggressive and being too aggressive by saying that not only do we want to toll the statute of limitations for matters that we are able to ascertain from 5 years back from this date, but we want to go back basically to the history of your corporation. If we find any other instances of bribery and corruption, we want the statute of limitations tolled against that. So Pat finds that is really an overreach going forward. He does acknowledge that the government has a significant amount of leverage in asking for this pause based upon the tolling agreement of the statute of limitations, and that he thinks it's really a rare company that would refuse to enter into a tolling agreement. What he really advocates is that you can actually negotiate with the government over some of these issues, and if the government takes this broad view or broad waiver view, Pat thinks that you need to push back on this because it's really not the purpose of a tolling agreement to allow the Department of Justice to investigate conduct which would have occurred prior to when it became actionable based upon the statute of limitations. So interesting argument by Pat. I would just say that I find this really consistent with Pat's overall approach when he was the head of the unit. I think he had an even-handed approach. He certainly, as a prosecutor, saw the need for prosecution, aggressive enforcement, but I don't think that certainly he did not publicly advocate a very strong and strident aggressive positions by the Department of Justice in things like tolling agreements and the background investigation. So I always found Pat's stewardship of the FCPA unit at the Department of Justice to be, I would characterize as even-handed. And this his thoughts at this conference, I find it to be really consistent with what I read and heard of him when he was with the Department of Justice. Okay, so next up, Jay, is our good friends at Starbucks. And I say our good friends at Starbucks because it's continuing the imbroglio that Starbucks found itself when they had two African-American men who were waiting for a colleague arrested for trespass. So this is something I think is going to keep Starbucks in the eye around compliance for quite some time. And the Matt Kelly, our colleague from the Everything Compliance podcast, took a look at it on his blog, Radical Compliance. I took a look at it on my blog from the risk management perspective. Matt looked at it from the compliance policy angle. And then we both explored both of those in this week's Compliance Into the Weeds podcast, episode 79. So I think there's lots of lessons there for the compliance practitioner, but I would encourage you to take a look at what Matt and I had to say on it.
So there are two things I'd like you to amplify if you could. Matt makes a nice point about how large organizations need to be nimble and responsive to changing situations. And you really go in quite in depth in your articles talking about the difference between forecasting an event and doing an actual risk assessment.
Correct. So, it's really interesting because Matt really articulated the balancing acts and the difficulty and what you really have to do in stating a broad policy, but giving the frontline supervisors who at Starbucks are the store managers enough leeway to have a wide variety of decisions available to them based upon the facts on the ground. So basically flexibility, and that means you have to train employees, but you also have to screen employees. You can't have someone who is going to be prejudiced against African Americans as a store manager when that prejudice would require, or through those eyes, they would then see a danger and require police arrest 2 men for trespassing. And what I saw, Jay, is what I wanted to question or ask people to think about is, what is the business of your organization? Because 25 years ago or 20 years ago, Starbucks sold coffee. But Starbucks really sells itself now and markets itself as something very different. Whether that be your home office away from home, whether that be a corporate, the common green, whether it be the common square or the third place for you to hang out, home office or Starbucks. If that's going to be what you sell yourself as inclusive, allowing people to hang out at your store, you have to do a little bit better job than they did.
Yeah, and I think what's interesting to look at is their response to the incident. There is a positive thing that they will be having a training session, closing all stores for half a day in May to do that. So that does mean that they've owned up that they've done something wrong. But in terms of damage control to the brand, it will remain to be seen if this is enough of a strong reaction to mollify the public.
Jay, and you're absolutely right. I appreciated their response. They gave a very strong response. But let me just focus on this stand down, one afternoon stand down for training. Think about the cost to Starbucks to do that. I don't know if it's on a U.S. only or worldwide basis, but even if it's U.S. only, this is going to cost them tens of millions, perhaps even hundreds of millions of dollars just in lost revenue. So these are the kinds of costs that are not often talked about in a situation like this, where you have huge reputational damage, even if you didn't violate the law. So this can be the kind of cost that you can have if you're not fully managing the risk that you have going forward. But I did appreciate Starbucks' response to date, and I look forward to seeing what they come up with.
Yep. So next up on our list, we have an article from the Washington Post by Tony Rahm. And the headline is Facebook's handpicked watchdogs gave it high marks for privacy, even as the tech giant lost control of user data. So what's interesting is they bring up a situation that when both Facebook and Google had issues with the FTC, that they were asked to bring on an independent third-party monitor to make sure that they were, dealing with data breach assessments. Both firms brought on PwC, who seem to have returned some very slim reports that the clients, being Facebook and being Google, were both in compliance, and then furthermore, going forward, it turned out that they weren't there. And what's interesting is we had somebody from the FTC, Megan Gray. She is also a fellow at the Stanford Law School Center for Internet and Society, and she called out the agency in a new research paper last week to consider changes to the way it brokers and enforces its own settlements with companies like Facebook, Google, and Uber. Under her proposal, the FTC would play a more active role in overseeing companies' privacy checkups, and those firms would have to turn over more information to the FTC so the watchdogs can ensure that they're protecting consumer privacy. In response, the FTC spokesman said that Gray is not working on privacy or data security investigations at the agency, including its probe into Facebook, and her article and any other comments represent her personal opinion and not the views of the FTC. So thoughts on that?
So I was really interested in your thoughts from working at affiliated monitors, because if the monitor comes in and does a whitewash or really doesn't do a good job, it doesn't do anyone any good. And it didn't do Facebook any good. It didn't do the FTC any good. It didn't do the public any good. So that I guess not to toot the horn of affiliated monitors, who sponsors this podcast, but you've got to have professional monitors who know what they're doing. So there you go.
Yeah, I will let you say it at that. Well said. So now we are getting to the part of the podcast where you tell us where you're traveling, what you're doing, and what's happening. So what's on your plate, Tom?
So we are just a few days away from having the book published, so looking forward to that. But I'm having quite an interesting May, Jay. The first full week in May, I'm speaking at the LEC. That's the Legal Ethics and Compliance International Compliance Congress in Sao Paulo, Brazil. Many of the listeners may recognize Carlos Ayers, who is I've had on my podcast from time to time, a good friend of the podcast and a well-known compliance practitioner from Sao Paulo. Was instrumental in getting me an invitation to go speak. I'm going to talk about metrics and data, something near and dear to my heart. That will be on May 8th, at the time of my talk. On May 17th, Thursday, May 17th, I'm talking to the Houston chapter of ACAMS, and my topic there will be driving compliance and ethics through data analysis. And then finally, at the end of the month, I'm speaking at Compliance Week, and I'm leading a session on using frameworks to provide compliance competency. And by that, I mean frameworks such as the 10 hallmarks, the COSO formulation, and others, and really see how you can converge those and how they integrate together to give you all a very a well-rounded, holistic approach to your compliance program. So I hope you can join. I'd love for you to join me in Sao Paulo. I recognize that may be a little problematic or at least difficult, but perhaps you'll be in Houston or Washington and can join me for one of those events. I know you're planning to be in Compliance Week 2018, I think, Jay.
Yeah, so I will definitely take you up on your offer in DC, and I will also be in San Francisco on May 18th for a one-day SCCE, the Society of Corporate Compliance and Ethics conference, and these are a real nice opportunity just to get together with fellow practitioners on our regional basis, and they do a great job of putting together these one-day seminars that you can get your CPE, but you can also catch up with folks. So I'm definitely looking forward to that. So 100 episodes.
So it's been really quite a ride, Jay, and appreciated Millie and Michaela introducing today's episode. I think as a dad, though, we do have to give you downgrade points because they could not explain what FCPA was. Although I would note it took me several years to get my daughter to spell that correctly. So we moved on to what it actually means, but she's a little bit older than your girl. So was very gratified that they were able to join us for the introduction. And you want to take us home?
Sure. So on behalf of Tom Fox, the compliance evangelist, and myself, Jay Rosen, Mr. Monitor, we would like to thank you for joining us for episode 100 of This Week in FCPA. We appreciate you taking time out of your day and your weekend to join us to discuss all things compliance and ethics in FCPA. And as Tom mentioned to me before we got on the air, we would be remiss to point out that the top two teams in Major League Baseball now are the Houston Astros and the Boston Red Sox. So once again, for Tom Fox and myself, Jay Rosen, thanks so much. Have a great weekend.
This is Tom Fox again. I hope you've enjoyed this 100th anniversary edition of This Week in FCPA. I hope you've enjoyed many of the other episodes throughout this podcast series, almost as much as Jay and I have enjoyed bringing them to you. If you have not done so and listened to this podcast on iTunes, I would greatly appreciate it if you would rate our podcast, as it would help in our rankings and help get the word out even broadly or more broadly about the only weekly wrap-up in compliance. You can reach Jay at jrosen@affiliatedmonitors.com. You can reach me at tfox@tfoxlaw.com. Thanks again for listening to this 100th anniversary episode of This Week in FCPA, and I hope you'll join us again next week where we take a look at the week's top compliance and ethics stories. This Week in FCPA is a part of the Compliance Podcast Network.